Hi, everyone, and welcome to the Thrive Co-Living Communities YouTube podcast. I'm Mark Stein, Thrive founder and your podcast host. We're creating sustainable, inclusive, and multi-generational residential communities. Our mission is to combat the epidemic of isolation, revitalize communities, and help others discover the many benefits of engaged community living by offering unique and ecologically sustainable co-living options. In this podcast series, join us as we discuss co-living, in addition to bringing you interesting people from around the world who are doing cool things to expand your knowledge and satisfy your curiosity. Through this podcast, learn more about our concept and see how Thrive co-living communities will bring together people from all walks of life who want to enjoy the best of independent and group living. To find out more about us, please visit our website at thrivecolivingcommunities.org. Thanks for watching and enjoy the podcast. Okay, hi again, everybody. Welcome back to the Thrive Co-Living Communities YouTube podcast. Today I have a special guest, Roy Myers. He is CEO, president, all of the above for Elder Care Financial Resources in Bardstown, Kentucky and Louisville, Kentucky. And today we're going to talk about a really important part of financial planning, and that is a living trust versus a last will and testament. And we'll talk about all two types of living trust, when you should have one, why you should have one, who should have one. And Roy has been in the senior business for a long time. So I'm going to let him talk a little bit about his background and how he got to this point, and how, Roy, how you started focusing on the importance of this instrument. So welcome.
Well, thanks for that introduction here, but let me kind of clarify a few points up front. I'm not an attorney. I actually been in this business for 40 some years in estate planning and retirement planning, and just ran about just everything you could run across in this type of business. But first got started in it with working with veterans on their pensions and finding out that there's a big need for estate planning out there, because most people have no clue what they have for the last will and testament, since that's the standard product most people go to. But so let's do a little comparison here, if you don't mind, between a last will and testament to a living trust, and even people that don't have anything at all. So I guess the best place to start with people that have nothing, no plan, no last will and testament. And the biggest assumption that people have, if you have nothing in place as far as estate planning, is that when one spouse passes away, the other spouse inherits everything. That's not quite how it works. Now I'm talking on Kentucky statutes for, it's called Dow courtesy. Okay, if you have nothing and you have a farm and a house, and one spouse passes away, their surviving spouse don't get 100% of that. They only get 50% of that. The children inherit the other 50%. So the kids would have to turn around and give that back to mom, or mom would have to sue the kids to get the rest of the estate. And a lot of people just don't realize that. That's a very complicated issue. So let's look at a last will and testament. Now, last will and testament has what they call a spousal inheritance, unlimited spousal inheritance, which says, in that case, if the spouse passes away, the surviving spouse gets everything. Okay.
That's a default assumption of a last will and testament, regardless of what's specified.
Well, you know, if you have a proper structured last will and testament, I've ran across some last will and testament that did not have that universal spousal inheritance issue. That has to be the language or legalese that's put into the last will and testament. So it's key to look for that very aspect of it, that, you know, the spouse would inherit everything with no probate and no taxes. It just automatically processes transfer. But the big problem comes in is when the second spouse passes away, because at that point, the surviving spouse, or the heirs of the surviving spouse, will have to go through probate. And that will last a minimum 6 months, and will last longer if there's complications or there's sizable estate. Now, in the state of Kentucky, we have what they call fast tracking. If your estate is less than $30,000, the probate process is about 30 minutes. You go in and say, here's the last will and testament. That's pretty much it. But if you have more than $30,000 in assets, you got kids who inherit property, and it could take anywhere from a year to 2 years. In one case here in Kentucky, that's friends of ours, took 5 years. And the family didn't get most of that. The attorneys got most of that because probate fees can go anywhere from 5 to 8%. And that's what the family has to pay in order to settle a probate. The thing about a last will and testament also is that a last will and testament is no good until you're dead. I mean, it doesn't do anything for you while you're living. And with today's, improved medical practices, there's a very, very good chance you could stay in a coma, or you could stay in a nursing home, you could stay in a hospital for years and years and years, and nothing is going to control your assets or take care of your assets. And the last will and testament is not going to do it until you're gone. And the thing about a living trust is a living trust will take care of your assets while you're living, protect your assets, and also after you're gone. So you get double the dose with a living trust, more than a last will and testament. That's some of the major concepts we've run across. Another one is that living trust is just a document. We find out a lot of attorneys, and I found out this for years. You go to an attorney and say, I need a trust. First of all, you need to tell them what kind of trust you need, because there's about as many types of trust as there are types of cars on the highway today. If you have a last will and testament and you go to your attorney that wrote the last will and testament and say, I want a trust, most likely you'll get a testamentary trust, which is part of your last will and testament and does not go into effect until you're deceased. So there again, you lose all the aspects of taking care of your assets and managing your assets while living if it's a testamentary trust. So you need to ask for a last will, a living trust if you go to an attorney. But here's the deal. They'll write up the trust for you in proper language and legalese and say, here's your trust. Now it's up to you to fund your trust. Funding your trust is putting your assets inside the trust. And most people sit there, scratch their head and say, how do I do that? And that's why we find out a lot of trusts out there are just totally worthless. They're a piece of paper because the trust has not been funded or their assets have not been put inside the trust. And that's why it's so key important that people get a trust together and then fund the assets or put the assets inside a trust so it is a legal binding document.
Who would it not be the attorney that would put the assets in the trust? Who does that? You
would think so, but we find out majority of the time they don't. You ask them to do a trust, they charge you a fee to write the trust up and say, they'll say, here's your trust. And that's about it. And they even don't tell you to fund it, or they tell you to fund it and you don't know how to do it, or you forget about it. So we find so many trusts out there are just totally worthless.
So who does assist people to fund the trust? And talk about, let's talk a little more in detail about the trust, the living trust.
Okay.
Discuss between revocable and irrevocable, and some of the things that can go into it and the benefits of doing it that way.
Okay, well, to approach that, let's talk a little bit about the living trust first. And most living trusts are what they call an A-B trust. You think A above ground, B below ground. It's an A-B trust, and when one of the spouses passes away, the trust is split into two halves. The surviving spouse's assets goes in the A trust above ground. The deceased spouse's assets go into the B trust, which is below ground, and the B trust is irrevocable. Okay, and there's a lot of trusts out there right now that need to be that were written decades ago that need to be modified. And here's the reason why: because the B trust is irrevocable. The only access that the surviving spouse has to that trust is usually called the 5 and 5 process, either 5% or 5,000, whichever is the largest. So that's the only access they have to the B trust assets. All the rest of it frozen. They can't get their hands on it. The kids can't get their hands on it. So it's a real big problem. We got one case here locally that there's $2 million in the B trust that the family gets their hands on, but they can't get to it. So that's why these old trusts that have been around for decades need to be modified for that very reason, is to get rid of the AB trust. And here's the reason for the AB trust, okay? I'm going back about 20 years from now. Okay. 20 years ago, the uniform gift tax was around $200,000. What does that mean? Well, the uniform gift tax is the same as a death tax. You know, most people are familiar with the death tax, which means that you had a $200,000 exemption 20 years ago, and you'd pay a 55% tax on any assets that were above that or inherited and had to be paid in 9 months. This is why so many farms in the state of Kentucky went up for sale, because the family didn't have that money. It was all tied up in land and farm. Okay. Well, that's been gradually increased over a period of years. Now, each taxpayer right now has about $5,250,000. So a couple together has over $10 million in exemption from the death tax. So that's really become a moot point with the living trust and the AB trust. There's really no reason for an AB trust now. So you need to modify the old living trust. You get rid of the AB aspect of it and just make it a living trust without the AB aspect, so you won't freeze that deceased portion's asset inside the trust. But that's one major issue we run across too. Another one is that when people say I have a trust, I look at them and say, well, what kind of trust do you have? And I get the deer in the headlights stare at me. He says, what are you talking about? Well, there's a whole world difference between a living trust and an asset protection trust, which is your irrevocable trust. A living trust will not protect your assets for nursing home and Medicaid, and will not protect your assets for major lawsuits. So now there's 3 parties to most trusts. The 3 parties are grantors, trustees, and beneficiaries. When you have a living trust, you wear all 3 hats. You're the grantor, you're the trustee, and you're the beneficiary. In the cases where you have spouses, if one spouse passes away, that surviving spouse is still the trustee. So
okay, go ahead. Just a second. If it's a couple, would they have 2 living trusts?
That's the ideal situation, but most cases we see just one living trust with 2 grantors involved.
Because, and maybe it's more important if you've got 2 working spouses, as opposed to a primary income producer and a supportive spouse. Is that accurate? It's more important to have 2 living trusts when you've got 2 professional people that have assets.
That's exactly right. Yes.
Okay.
But if you got one, income producer spouse and one dependent spouse, 1 living trust is adequate enough.
Okay.
But like you said, if you got 2 producing spouses, it's more flexibility built into the ability to create 2 living trusts. Okay, that work together. Okay.
All right.
But as long as the grantors are living, they control the assets inside the trust. They can do anything with their assets. There's no limitations there whatsoever. The big benefit about a living trust, though, it eliminates that probate process. Okay. And the time element involved in probate, and also the money element in probate. If you have just the last will and testament, you're looking at least a year before you get your mom and dad's estate settled, and a year before you get any inheritance. With living trust, I've had them settle the living trust in a week's time, sitting at the kitchen table, no attorneys and no courts involved. They're beautiful aspects.
The assets automatically go to the recipient, and grantor is the person who has the trust, who owns the trust, correct?
Right. Yeah.
Okay, go ahead.
So the family, when mom and dad are gone, the kids sit at the kitchen table, say, you get this, you get this, you get this, and it's over with. That's pretty much it. The only thing you need is a death certificate if you have to liquidate some of the assets. So it takes about 30 days to get everything settled and in the kids' hands. Okay.
What's the role of the trustee if everything happens automatically? What's a trustee needed for?
Well, the trustee it comes into play more in the concept of when you have mom and dad. Okay. Mom and dad they're doing okay, but with the overwhelming problem with Alzheimer's these days, if mom and dad become incapacitated, they can't manage their assets, this is when the trustee steps into their shoes and manages those assets on their behalf for their benefit. And the trustee cannot manage those assets or take any money out of those assets that's not beneficial for mom and dad. Okay, because mom and dad are the primary beneficiaries at that point. The family does not become beneficiaries until mom and dad's gone, and then the trustee manages assets for the benefits of the heirs to the trust or beneficiaries.
Does a trustee need to be a professional certified person, or can a trustee be a family member?
Yes, the trustee can be a family member and at least needs to be at least 18 years or older in the state of Kentucky, or age of majority, before they can do anything with the assets of the trust. But no, a family member, even a friend, can be the trustee of a trust. You don't have to have a professional service like a bank or other company to do that. Now, in some cases, families prefer that because they don't want their kids to get in a fight over the assets, and sometimes that does happen too.
Let's say, let me give you a for instance. Let's say that you've got two children and one child, and they're adult children. One child manages money pretty well, and the other one would just as soon drink it up, coke it up,
Yeah,
as anything.
yeah,
And you specify that you want this drinking child to get $3,000 a month, or special dispensation if they have a damn good reason for doing it. They want to send a child to college. Is that a good reason to have a professional trustee, and maybe and I think that there's some certifications in order for a professional person to be a trustee. I think they have to have certain criteria so that they make good professional decisions and they're not swayed by emotion with this drinking child. Talk a little bit about
yeah.
that.
Now you talk about fiduciary responsibility of a professional person, yeah, and that's very true, because that fiduciary cannot violate the provisions of the trust. It's a $5,000 fine per instance, in 10 years in prison, so they're not going to violate that. And that's a good concept to have if you've got kids that can't manage money, or if you got a kid on cocaine or something like that. That's definitely is a professional manager should be, but you need to check their credentials, make sure they're at least at fiduciary capacity, so there won't be any possibility of them, embezzling any money from the trust itself too. But yeah, that is a problem. There again, when you get a successor trustee is the trustee that would take over mom and dad's position. The trustee is actually mom and dad. A successor trustee would be the kids. Okay, if mom and dad are incapacitated, they can't manage it. But in most cases, successor trustees are also beneficiaries of the family. So there again, you want to assign that person to someone that's had some experience in either legal aspects or financial aspects, or knows how to manage those aspects too, because there may not be a fiduciary responsibility on that person's part, but they're still legally liable to manage the assets inside the trust according to mom and dad's, request.
Back to the fiduciary one more moment before we move on. Are there certain professions that can only do that? Do they have to be a lawyer, an accountant, a financial advisor, all the above? And how would you go about finding someone who would professionally manage your trust?
Well, the best thing to do is pick up the phone book and look under the provision banks, because a lot of them say bank and trust company. So they're to have a trust division that does that very aspect for families.
Okay.
But of course, they're going to charge you an ongoing fee to do that, whereas a family member wouldn't charge you a fee for doing that. But there again, but you're going to find out people that are investment advisors, investment advisor representatives, stockbrokers, or advisors are not want to take on that responsibility. They just don't want to do that because it can cost a lot of family members. And you get an irate kid, they get phone calls left and right. I need money. I need money. I need money. So the best place to go is an institute instead of an individual, and that's where you need to look at bank and trust companies and approach them for that very service.
Are they going to charge you monthly, yearly fee
Oh,
to
yes,
be
they
a
will.
trustee, even
Yes, they
if
will.
they're not having to do anything?
Yes, they will. Yes, they will. Well, just like you're a broker or investment advisor, they may not do anything on a monthly basis, but they charge you fees, ongoing fees. That's how they survive. And it will be the same way with a bank and trust company or any professional advisor that you choose for that purpose.
Can you give a range of what's reasonable?
No, it's totally across the board. Now,
Okay.
when it comes to investment advisors and brokers like that, their fee is usually around 1%. But when it comes to banks and institutes like that, it's kind of across the board.
Okay. And probably if you do business with a certain bank and you've got some liquid assets, cash in their bank, they're probably going to be more amenable and
Oh yeah, they will be.
and cheaper fees.
Yeah, exactly. Cheaper fees. Um,
Okay, go ahead.
Another aspect I like to bring up between the comparison between the last will and testament and living trust is this. Anyone can challenge a last will and testament, and anyone can challenge a trust. So let's talk about challenging a trust and last will and testament. The process, if you got an irate kid, and you get a lot of blended families today, you got one side of the family don't agree with the other side of the family. But if you get in an argument like that, there's going to be some trust, last will and testament challenges. What happens there is all the assets are frozen. None of the kids can get any money. Now it's got to go to court to see if this challenge is valid or not. But all those assets are tied up. Now, if we have a last will and testament, the assets are inside a last will and a living trust. Someone challenges the trust, the assets are not frozen. The kids can still benefit from those assets, even though there's a challenge on the living trust itself, which is another big benefit for doing these types of trust itself.
So everything keeps moving, and then let's say a challenger is successful, then the court would order the trustee to redistribute or that sort of thing, right?
Yeah, and if you kind of read between the lines here, if you're under the impression something's going to be challenged after mom and dad passes away, the trustee actually can bleed out all the assets out of the trust and give them the kids. So if there's a lawsuit that wins against the trust, there's nothing in the trust to win.
But then they'd have to sue the kids.
Yeah, then they have to answer the kids. Yeah, so more court fees and if it's 10 times harder to have a successful challenge of a trust than it is the last will and testament.
Okay.
So
another example that I can see would have some real benefits of a living trust is passing along a business. You don't want that business operations to be frozen. You want that business to keep moving, and passing along the business inside of a living trust sounds like it's ideal.
Yeah, that's ideal. And a lot of people will, kind of coordinate a family limited partnership and a living trust also with the minority owner of the family limited partnership owned by the trust itself. Because remember, there is no asset protection from any lawsuits in a living trust. So they'll make the limited partner the grantors or owners of the living trust for another level of asset protection.
You lost me on this one. Can you repeat that?
Well, you've heard family limited partnerships. There's a majority owner and a minority owner. Okay. And usually the minority owner controls the business itself. So they'll construct a family limited partnership and also a living trust. And the grantor of the living trust is the limited partner of the family limited partnership. So they kind of work together to give us another level of asset protection that's not provided by a living trust itself.
Okay. What sorts of things can you put into a living trust, and what's common? What's the most common?
I'm glad you asked that question. We run across a lot of people that have, life insurance, retirement accounts, 401ks that have a beneficiary on. Okay. Any type of financial product that has a beneficiary designation does not go through probate. Okay. So that does the same thing as a living trust. And they said, well, I don't need a living trust because I've got all these beneficiaries on all my assets. Okay. Well, instead of Kentucky, you can't do that with a property. Okay. That's called a ladybird trust, which came out of Texas. But you can't put a beneficiary in property. So one of the biggest assets of a living trust is the house or the farm. But think about this. If you've got a life insurance contract or you got $500,000 in your IRA account that your kid's going to inherit it is not a good idea to have them kids inherit all that money at one time, because in most cases, they'll just blow it. So instead, the beneficiary in your life insurance or retirement account, have the beneficiary of your living trust. That way you have dead arms control of that asset even after you're gone. With a life insurance contract, 401ks, you do not have dead arm control. They get it and they do whatever they want with it. But with a living trust as beneficiary, you have dead arm control.
And are you saying dead arm?
Dead arm, yes, that's what it's called. And controlling your assets after you're gone, dead arm control.
Okay, so you could say, George, the drinker, is going to get $2,000 a month out of that life insurance. It's coming out of the life insurance.
Yeah, exactly. Or they don't get anything to age 25 or age 30, or they get $5,000 at age 25, another $5,000 at age 30. Anyhow, any way you want to set it up in a living trust.
Okay. Talk about the difference between a revocable, and you talked a little bit about irrevocable trust.
Okay. I explained the parties to a living trust, and that's the grantors, the trustees, and beneficiaries, and they wear all three hats. It's a different story with the irrevocable trust. In an irrevocable trust, there's the grantor, the trustee, and beneficiary, but the grantor and the trustee are separate persons. Okay. And here's where you have to understand this. These are irrevocable trusts. And once the grantor sets the trust up and puts their assets inside the trust, they don't own that asset anymore. Here's the concept. If you don't own it, nobody can take it away from you. Okay.
Or you can't be taxed on it.
No, not quite.
Oh,
not quite.
It's terrible.
Not quite.
Not own it, not control it.
I'll get to that in a minute.
Taxed on it? No way.
I'll get
Go
to
ahead.
that in a minute. But the concept is the trustee manages all the assets inside the trust. Now, here's the, with a specific type of trust, I'll talk about it in a few minutes. Here's the control the grantors have. They can fire the trustee and appoint another trustee, and they can also control the percentage of percentage that the heirs receive on the trust itself. That's the only control they have. But a lot of times this scares off a lot of people. Remember, the grantor, once they put the assets inside the trust, they don't own it, they can't manage it, they can't do anything with it. That's a responsibility of the trustee. But in cases where you have a house and land, there's really no assets to be managed there. You just put a house and land in there. The only time the trustee would get involved is when you sell the house or when you sell the land, or you lease out the land for a farm income. So that's the only time a trustee would get involved with the irrevocable trust. Anything else, they can put a extension on the house, they can paint the house, they can do anything with the house they want to. But if they sell the house, they got to go to the trustee to do that. Okay. But a lot of people
if you don't own the house, you own it and can't control it. How can you sell it if you don't own it?
You don't own it. Okay. You don't own the house. The trust owns the house. The trust got its own tax ID number, just like a person. So the grantor doesn't own it. Okay. But they can sell it, but they have to get their trustee to sell it for them.
Why would you want to create such an instrument? What are the motives that would lead you to do that?
Well, the concept is, if you don't own it, no one can take it away from you. There's a lot of people out here that don't have long-term care insurance. If they went in a nursing home, nursing home and Medicaid can attach that property to be reimbursed after they pass away. And we've seen several huge farms in Kentucky disappear for that very reason. But once you transfer the assets inside of the trust, you have to get through 5 years with Medicaid, look back. But once you're in there for 5 years, 5 years in one day, if you go in a nursing home, the nursing home cannot touch the assets you put inside that trust.
And you're
because
going to put them in there for the benefit of your children, of your heirs.
yes.
So the kids, so that's it. The kids get the house, and Medicaid, Medicare, whoever can't touch it.
That's exactly right. That's asset protection. Okay.
So, and would you only do that with a house and property?
No, we do a lot of farms too,
Okay.
or any appreciated assets that has a high value.
So you probably would want to know, you'd want to keep control as long as you can. But I guess is it age driven, that once you hit a certain age, when you're more likely to start, like 5 years from now, I know that because of how my mind is working, I'm going to likely need some care. I don't know. How do you decide when to put it in an irrevocable trust?
Well, I get a lot of questions about that. When should I start a irrevocable trust? And I always said 5 years ago is when you should have started it, because the 5 year look back on Medicaid. But it's really not age driven. Of course, the older you get, should be more of a concern for you about, going to the nursing home. And 90% of people out there don't have any long term care insurance or no way to pay it. So how are you going to pay it? The families will have to liquidate assets to pay it, or Medicaid's going to reimburse you if they have to pay it. So, right now is the time to look into that. But the 5 year problem is that would be the best way to set up an irrevocable trust for that very reason. But let's say you set up an irrevocable trust. We have elderly people, they're in their 90s. Okay. They got a farm and they got a house. So we set up the trust and try to get through the 5 year period. So let's play devil's advocate, say 3 years into the deal, they're not past 5 years. They've got to sell the farm. They got to go in a nursing home. So how do we pay this? There's another trust out there. It's called a pooled trust. Okay. I know I'm getting real complicated here, but a pooled trust will protect your assets from Medicaid seizure. And there's no time limit on it. If you set up a pooled trust and 2 months later you go into a nursing home, the assets you put in the pooled trust are protected from Medicaid, but you can only put cash assets in the pooled trust. You can't put a farm or a house in there. So if we set up a living trust and put the farm and house in there, living trust, the ideal scenario would be to get to 5 years and apply for Medicaid, because the family can inherit the farm or the house. But if they don't, 3 years into the program, you're a nurse. We've got to sell the farm, we've got to sell the house, and put that cash inside the pooled trust and protect the cash value of it. We can't put a farm and we can't put real estate inside a pooled trust. So there's ways around it.
So now talk about revocable and what your strategy sounds like. Your strategy should be create a revocable if you're in your 60s, and then move the land to an irrevocable as you're approaching 70s, 80s, that sort of thing. Is that?
Yeah, that's feasible too. But we need to talk about, we get a lot of people to try to get savvy on this type of estate planning. They come back and say, well, I'm going to give my farm to my kid. That way I don't have to worry about Medicaid getting, or I'm going to sell my farm or house to my kid for $1. Well, the IRS has got very wise to that. And here's the problems involved in that. If you give a farm or you give your house to your kids, they don't receive it at fair market value. They receive it at what you paid for or you built it for. Let me give you an example, okay? Let's say your house right now is worth $200,000 right now, fair market value, and you bought the house 50 years ago for $50,000. That's the basis. The difference between those two is called the stepped-up basis. So the difference between 50 and 200,000 is $150,000. So if you give your house to the kids and they turn around and sell it, they'll have to pay a capital gains tax on $150,000. Okay.
But not if you put it in a revocable trust for their benefit, correct?
Right. Because a revocable trust has a legalese built into it that says if you sell the farm or you inherit the farm, you receive it at fair market value and you don't have to pay the capital gains tax on that. Okay. The specific type of trust we use is called I know it's complicated. It's called an intentionally defective grant or trust. Okay. And it's intentionally defective is a good aspect because it's intentionally defective from the purpose of taxes. You mentioned
It doesn't sound very good. It's not a good marketing term, is it?
exactly right. I really have to clarify that when I tell people. Well,
I'm gonna sell you an intentionally defective stove.
Well, it's intentionally defective from the standpoint of taxes. You mentioned it just a few minutes ago. Well, you don't have to pay taxes on assets you put in trust. Yes, you do. You don't get around that. But here's the deal. Just a normal grantor's trust, and you put like an investment in there and it earns a lot of money. The tax structure on a typical irrevocable trust is a higher tax rate than an individual rate. Okay. But if you set it up as an intentionally defective grantor's trust, you put that assets in there, even though it earns a higher rate of interest, you only pay taxes at your ordinary rate and not at the trust rate. Okay. I know that sounds complicated, but example, like a farm. We're talking about property taxes at this point. You put your farm or your house inside an irrevocable grantor's trust or intentionally defective grantor's trust. You would think that the trust pays the taxes or property taxes on it. And that's not the case. The individual pays that property taxes. And the IRS says if you pay taxes on it, you own it. So when you pass away, you know that person doesn't have to pay that capital gains tax that inherits the property. Okay.
Okay.
I know it's getting real complicated on these issues, but people really need to look into these asset protections and estate planning products because it's getting to the point you got to protect your assets from the federal government. Well, let me give you an example. We really passed a bullet back here in January or February this year when the new Congress got into session. I just talked to you about a last will and testament right now. If you have a last will and testament, mom and dad pass away, you inherit the house. You inherit the house at fair market value, and you can turn around and sell it and not pay a capital gains tax of 15 to 20%. Okay. But they were trying to pass a law in Congress in February this year that said, even though you have a last will and testament, when you inherit that property, you have to pay the capital gains tax that day. It's called deemed inheritance. The deemed inheritance prior to that says, well, if you inherit that, you get it at fair market value. But the new law says when you receive that property, they have inheritance, you have to sell that property, and there's no stepped up in basis. You'd have to pay the capital gains tax on that stepped up in basis, or $150,000 on the example I just gave you. That bill failed to pass Congress only by one vote. So it's going to be coming up again. So if you set up these types of trusts before that law is passed, there's a provision in the Constitution called ex post facto, which means you cannot make something illegal now that was legal when you did it. So if you set this intentionally defective grantor's trust now and put your assets in there and they pass that law, you'll most likely be okay when you do pass away because you set that up before they passed the new law. Mm. So, but Congress they're trying to get tax dollars any way, every way they possibly can. The $525,000 exemption on inheritance tax or uniform gift tax I just explained to you a few minutes ago. They're thinking about moving that from $5 million down to $1 million exemption, and moving capital gains tax from 20% to 40%. So just sitting back and say, well, I'm going to do something if this happens, it's too late. You need to make these changes before that happens, so you'd be grandfathered in on an ex post facto.
I hate to get political here, but I think it's probably pretty clear that Democrats would seek to increase the tax income, and Republicans will fight it. Is that how it currently works?
That's how it's checking out. Yeah.
Okay.
Yeah.
So one of the things I read about a revocable trust that really is, I won't say it's appealing, but seems beneficial, is that when you're still alive and you need medical care, then your trust is funding that medical care, whatever it happens to be, out of pocket on Medicare insurance, whatever, nursing home.
Right.
And then as soon as you're gone, then it's going to go to your heirs. So that seems to be a real benefit for people who are concerned that they don't want to, they've got a decent amount of assets and they don't want to burden their children with medical bills, especially if they're sick or infirm for quite a bit of time. Talk a little bit about that.
That's a good point you brought up, and I want to elaborate on that just a little bit. With the last, let's take a living trust. Remember, you wearing all three hats. You're the grantor, trustee, and beneficiary. There's a lot of people out here today that don't have any medical insurance at all. Fortunately, I deal with people that have Medicare and in Medicare supplements that pays the medical bills. But for those people underage that don't have anything, what happens if they go in the hospital and don't have any medical insurance and run up $100,000 bills? They can't pay it. The alternative, they're going to put liens on their property. So they'll know if they sell the property, they'll get it somehow down the road. But if you have an irrevocable trust, remember, you don't own the assets that's inside the irrevocable trust. So if your house and your farm and your cars inside the irrevocable trust, and that very thing happens, you run up a $100,000 medical bill, you don't have any medical insurance to pay it, they can't put liens on your property because you don't own that property. See? So if you sell it, it's free and clear at that point. And they won't have to pay off that medical bill. Now, I have to be very careful here because you cannot do this for illegal purposes. What I'm getting at, if you are facing $250,000 medical bills right now, you can't go out and set up an irrevocable trust and put your assets in there because it's too late. You have to do this where they say, well, your waters are clear or they're not in a way. When things are normal, you can't do asset protection to avoid something that's already taken place or do an illegal activity.
Okay.
So it has to be done in advance.
But your example was with an irrevocable, but a revocable trust is still going to give you some it's going to pay. It's not going to be exempt, but it's going to pay it. Is that right?
Yes, that's right.
Okay.
Yeah, that's right. Now, when we talk about irrevocable grantor's trust, intentionally defective grantor's trust, just this term irrevocable scares off a lot of senior citizens. So let me kind of walk you through that. Remember, three parties to the trust: the grantors, trustees, and beneficiaries. And the irrevocable trust, the intentionally defective irrevocable trust, the grantor and trustee are two different people. Usually the trustee is a trusted child, okay? Well, the irrevocable aspect of this type of trust is irrevocable only from the grantors, mom and dad. They set it up. They can't change anything inside the trust. But state of Kentucky belongs to a uniform trust agreement, which means that you can dissolve that trust if all parties to the trust are in agreement. The grantors, trustees, and beneficiaries, they can dissolve the trust and put the assets back in mom and dad's name. Okay, so it's irrevocable, but it's revocable too, from the standpoint of every party in that trust. So that kind of gives a lot of people comfort to know that if things don't work out with this irrevocable trust down the road for whatever reason, we can dissolve the trust and still put the assets back in their name.
So my guess is that a hell of a lot more about these trusts than most attorneys, unless they specialize in trust.
Right.
Excuse me. So my guess is that if I approach the average attorney, they are not going to be well educated or experienced about this situation.
That's very true.
And probably there are not many people, period, that have this kind of focus that you have had, especially as a non-lawyer specializing in trust.
Right.
So would the ideal be, okay, first of all, let me test my assumption. Is that accurate?
Pretty accurate.
And if I'm going to find somebody with as much experience and background as you, I'm going to pay a hefty price to a lawyer that has that kind of experience.
Yeah.
Is that right?
Well, yeah. See, that kind of put me in a unique position. I've got 40 years experience in this. That gives I have the ability to go to these attorneys. I don't write up the trust. I have the attorneys write up the trust. Okay. And that gives me the ability to approach some of these top-notch trust attorneys and negotiate with them because they know what the hell I'm talking about. I know how to digger with them on these aspects. I know what they do. I know what they don't do. But that gives me the ability to get these prices down to where they're affordable. Our prices for these types of trusts is about half of what an estate planning attorney would charge.
And if I'm going to find somebody with your experience, and I'm not just blowing smoke up your shorts, you have exhibited that you have a lot of knowledge about this. I'm probably going to have to go to a top law firm in a big city, and there are probably a half a dozen lawyers in the uppermost law firms in a big city that have this kind of experience. Is that and focus? Is that right?
And you're talking about 5-figure fees on this too. But yeah, you're right. You're going to pay if you go to a top-notch firm, you're going to get top-notch prices. Okay. But here's the deal. You can go to a local attorney and they're most likely going to set up either a testamentary trust for you or a living trust for you because that's what they're familiar with. When you get in these other trusts, like a tissue defective grantors trust, they have to do research and all that other stuff to get them up. And that's when they usually call me because I'm well known for this in this area to set up these types of trust. But here's the thing. If you go to a local attorney to do this, there's always laws and tax regulations that change through the year. And if something changes that's going to affect your trust or the outcome of the settlement of your trust, that attorney is not going to contact you. We do. We keep in regular touch. Our trustees hear from us every 6 to 12 months. If there's a new law comes out, we send out a letter saying this is a possibility that could change your trust outcome. And if it does, we'll be there to help you through this and hold your hand through the whole process. But you're not going to get that type of service just from a regular attorney or even a professional attorney.
So I know you're going to have some biases here, but would it be your suggestion to work with you or someone like you that has the experience to do the initial explanation of what you have and what you want to do, and then have you giving the instructions to the lawyer on how to make this happen, and for you to advise the family on no, you don't want to do that with this, you want to do this with that.
Right.
Is that the way you work with the lawyers, that you're essentially?
Yes, exactly right. Yeah, that's exactly what I advise the attorneys on how to put the trust together and what purpose for putting the trust together. And I, stand behind them and look over their shoulder, proofread every trust before it's actually signed and put into effect also.
Do your clients actually meet with the attorney, or do they meet with you and you give the instructions to the attorney?
No, they meet with me and the attorney. Okay, either in person or by Zoom. Okay, but that's a key aspect of it because we give ongoing advice and consultations on these trusts at no additional cost. We just have a one-time fee and that's it. There's no other cost involved, even when it comes down to the settlement or the state settlement itself. But that's a key issue because tax laws are changing so fast. Legal regulations are changing so fast. And the average person is just not going to keep up with it. That's our job, is to keep up with that daily issue and notify these people of any changes that come about in these laws that would change their outcome.
I see a parallel in this role that you're playing with the role that I played as a divorce mediator, where people were coming to me who didn't want to fight. They wanted to care for their kids jointly. And I would help them craft an agreement that the terms of the agreement that lived up to what they wanted, as opposed to them going to attorneys who would filter it through their own interest, the legal. Oh, well, the law says, well, if they agree on no child support and they give good reason, they can avoid the child support. So I would think I was serving in a similar role where I was instructing the attorney on how to accomplish what the clients want to accomplish.
That's a good analogy. Yeah, exactly. So yeah, I'm kind of the mediator between the families and the attorneys. Okay.
Mm-hmm.
And we sit down with the attorneys, and I pick the top attorneys to do this and know what they're talking about. I'll deal with some local attorneys, but that gets to the point I almost have to educate the attorneys on how to do this. But we hold their family's hand through the whole aspect of creating the trust, and we also go in and move those assets inside the trust, which most attorneys won't do. We do that also, make sure the trust is complete in its legal aspect. But we
You
hold
can
their
help
hand.
people fund it
Yeah.
fund it and move things in and out. You're able to do that.
And a person doesn't want to do that on their own because there are big tax consequences on that if you don't do it right.
Mm-hmm.
That's the important factor of that.
I have a question that you may not have ever been asked, but hell, you may not have been asked half these questions that I've asked you. But what about liability for you? If anything goes wrong in this thing, is the attorney liable and you're not?
Oh no, that's not the case at all. I have to carry liability insurance myself too.
Okay.
But I make sure that what the attorneys doesn't create a liability situation. And that's why it's so important to have a mediator like this, because if you're dealing with an attorney that only maybe does 1 or 2 trusts a year, that's a good possibility that a liability situation could evolve by him not putting the trust together. But I'm there to look over his shoulder, make sure that doesn't happen.
Mm-hmm.
But I have to carry liability too.
To me, as I was researching this, just mainly YouTube, I got my degree on YouTube.
Yeah.
The conclusion I drew was that there is almost no one who can't benefit from a living trust. Talk about who doesn't benefit from it. I think it's that threshold about $30,000 or something.
Yeah, right.
Who doesn't need it, and anybody above this does need it.
Well, you kind of hit the nail on the head. If you have assets less than $30,000, the last one testament is going to do fine for you because it'll be fast tracked and go through probate real easily. But here's what most people don't realize: mom and dad are living. In many cases, dad has $100,000, $200,000, $500,000 life insurance. Well, people realize that life insurance proceeds are tax free. They don't go through probate when the husband dies. But now once it's paid out, mom's got it, and she puts it in a savings account or something like that. That has to go through probate when she passes away. So you may not have a whole lot of assets right now, but when someone dies, you could have quite a bit of assets.
And I bet when people think about what their assets are, I bet they think about money in the bank, equity in their home, and they're not thinking about that $100,000 standard life insurance policy.
Right. And a lot of people, I'm glad you said that very issue. It's not the equity in your home that's considered in probate. It's the full value of your home that's considered for probate. And of course, there's got to be all those appraisals of value. And although it's got to be put in a local newspaper, I'm the executor of this last will and testament, doesn't know there's any claims. It's a very public issue. With a trust, a living trust, that's not done. It's a very private issue. It's just among the family. There's nothing published in the newspaper. You can go down to probate court and look at anybody that had their estate settled by last will and testament. You can see exactly what the family inherited, how much they inherited, and when they got it. That doesn't happen with a living trust. There's no public issue involved there at all. And believe me, there are people that do go to probate court for that very reason, to get that information to sell to other vendors so they can, jump on these people that just inherited a lot of money.
So let's say somebody has an estate, total estate, let's say $500,000, just to give a round number.
Okay.
So it's not a whole lot, but it's not nothing.
Mm-hmm.
So what could they expect to pay between your fee and the legal fees, ballpark? I know it has to vary widely, but what should they expect, ballpark?
Okay, good question. If you go to a professional, say, paying attorneys to get these documents together, the last will and testament and living trust, you're looking at about $13,000. And our
You go
fees
right to an attorney.
right to the top attorney.
Okay.
And they may not help you with the funding of the trust, and they're definitely not going to keep in touch with you about any tax law changes or legal changes that will affect the trust down the road. Our fees are, we max out at $4,000. That's it. That's all everyone ever will pay with us. We charge no consultation fees, no visiting fees. You can call us at any time. No fees involved. And that's setting up the trust. That's actually setting up two trusts, power of attorney, two power of attorneys, medical directives, and a pour over will. So there's about 8 documents involved in that. Even though you have a living will, last will and testament, I mean, a living trust, you still have to have a last will and testament. Okay. You think that's crazy, but here's the reason why. You want to put your big assets inside the trust, the living trust. You want to leave something out, maybe an old car, an old truck that would go through the last will and testament, because that closes the probate process. Okay. The courts like to close that process of 6 to 9 months. And once that window is closed, there's no one who can challenge that estate from that point on. So that's the purpose for a living trust or a pour over will. Getting back to the question you asked, as I said, $4,000 is the maximum we charge. That's less than half of what most professionals in this area will charge. And there's no ongoing fees. There's no fees when the trust is settled. That's it. Just a one flat fee.
And then that's including the attorney work?
Yes. Yeah. Say, I'm pretty good negotiator.
Yeah, put their knuckles in a vise.
Yeah, exactly.
Like. What else should I have asked you, or would you like to share? I know there's tons about this, and I can tell you have tons of knowledge about it, but what are other key points that we haven't talked about, and I haven't asked about?
Well, there's an issue of what they call the homestead exemption. Right now, the homestead exemption in Kentucky is $44,500 on property value. What that means is each year when you pay your property taxes, if you're 65 years older or you're totally disabled, you're not taxed on the first $44,500. That's the homestead exemption. Okay. But if you're 65 years older or disabled and you give that to a kid, that exemption is gone. Okay. So it's a key issue that your trust, we talk about irrevocable trust at this point, that trust has the language or legal lease in it that maintains the homestead exemption. So if you put your farm or house inside the trust, you still have the exemption of $44,500 that you don't pay the first property taxes on. Okay. But there's multiple reasons for using these types of trusts, but the primary reason that most people come to us is because they don't have long-term care insurance, and then we can set up the trust in lieu of them buying long-term care insurance, because they'll pay through the nose for paying long-term care insurance. You know, at our age, you're looking at $4,000 to $5,000 for a decent long-term care insurance policy, and most people don't have that money. So we set up a trust for that very reason, in lieu of not having long-term care insurance. The trust is not going to pay for the care, but it will prevent Medicaid and nursing home from taking all your assets that your family will inherit. And today, and especially today's economy, you have to realize your kids are looking to their inheritance to complete their own retirement plan or to prop up their own retirement plan. So it's just not planning for you. It's actually planning for your kids that's going to inherit your assets too. So there's multiple reasons for doing these types of trusts, and we could talk days and days on. But those are the primary reasons that most people look at this is, you know, trusts are becoming, people think trusts are only for wealthy people. They're not. They're for people that, you know, if you have assets over $30,000, the trust is ideal for you. Just to make sure that nursing home don't get it, or that it's inherited by your family too.
I guess it doesn't matter. Doesn't matter where you are in terms of career. You can benefit from this whether you're still working or retired,
Oh,
as long as
definitely.
you
Yeah.
have assets.
Yeah, you're definitely. That's true. Very true. Then the sooner you do it, the better off your family will be.
Right, because you don't want that, especially if you're older, you don't want that 5 years window
Mhm.
to catch you.
Right.
Before I ask you your contact information, let me just tell you a funny story. And I don't think I've ever told this. There was a comedian on Johnny Carson, which tells you how old this is. And they were talking about life insurance. And the comedian, I forget his name, but he said, I don't have life insurance. I don't own any of it. He said, when I die, I want it to be a total tragedy.
It probably would be too.
Yeah, I don't want anybody to be the least bit happy that I'm gone. So this has been really valuable, and I'm glad that I've done a little research so that I can ask you. Hopefully, I asked you better questions and more informed questions.
Yeah.
But I feel like you gave us a good bit of information that was really valuable for a lot of people and our listeners. If
Right.
someone would, oh, can you only provide services for in the state of Kentucky?
No, we write our trusts based upon the jurisdiction. It doesn't matter where you're at; it would conform to that jurisdiction you're in.
As long as you're in the United States.
Yep.
Okay. So if someone wanted to reach out to you for a question or to have you help them, what's the best ways for them to reach you?
Phone number would be the best. It's phone number here is 502-275-4427. Again, it's 502-275-4427. Now, I may not answer the phone, but leave a message and I'll call you back within 24 hours. I get so many darn robocalls that, it's difficult to answer all robocalls and customers too. So most likely you'll get the answering service, but leave your name and number and I'll call you back within 24 hours. My cell phone number is, I can text and take a message on that too, is 502-349-2578. Again, it's 502-349-2578, or you can email me. My email address is Roy, ROYON, like Oscar Dancy, 2578 @gmail.com, ROYON 2578 @gmail.com.
And your website, I know you told me at the beginning that you're having some problems with it. So
Yeah.
once you get that resolved, and should be, the website, the web address is
eldercarefinancialresources.com.
Got it.
And we got some good videos on there from customers too that people like to watch.
Great. Well, I sure appreciate this information. I feel like you just are an extreme expert in this field. So I feel like it was really valuable, and I thank you very much.
Well, there's no expert in any field, just some people know more than others.
And spent more time researching.
Yeah, exactly.
So, all right. So thanks, everybody. Glad that you were able to join in. Hope you enjoyed it and got a lot out of this. For those who are tuning in regularly, you know that we cover a variety of different topics, from sustainability to solar energy, all types of emotional sorts of responses and processes. If you want to support the podcast and our endeavor, go to thrivecolivingcommunities.org. And we also have put different ways to support us: Patreon, crowdfunding. Those are down in the show notes. So we certainly welcome that support. Otherwise, the best thing that you can do is like our videos, subscribe, and keep coming back to watch them. We're also open to your comments. So please feel free to share your comments or to suggest someone to be on the podcast. Roy, thanks again. And thank you, everyone. We'll see you next time. Thanks for joining us for another great episode of the Thrive Co-Living Communities YouTube podcast. To learn more about our mission and how you can support our vision of creating co-living communities worldwide, please visit us at thrivecolivingcommunities.org. To receive advanced viewings of our podcast and other exclusive content, find us on Patreon at patreon.com/Thrive Co-Living Communities. You can also learn more ways to support our mission in the show notes below. Amazon Smile, GoFundMe, Kroger, and our own Thrive Gear store, where you can buy t-shirts, hats, and many other items. Thanks again for tuning in, and we'll look forward to seeing you again soon.